Hi, everybody. Harry here to talk about the final round of briefs in the all-important case of Illinois versus Trump, which were filed yesterday. Recall, this is a case in which Trump, as in many other, has attempted to federalize the National Guard in Illinois and for good measure send in some willing federalized guards from Texas, where the high officials have said, "Oh, yes, we'll be happy to go in and help out our neighbor to the north, our very blue neighbor to the north." And recall what has happened here. So we've had the general kind of issues about 10 U.S.C. 12406 and the all-important lurking issue of to what degree does the Supreme Court give Trump deference, either as the United States has claimed as its primary argument, just to not review it all. They just have to say that's for whatever the Trump administration or the executive says, or even to some degree of deference. But there's the cases out there which have very sensibly said that doesn't mean you just green light determinations untethered to the facts. And this case took a dramatic turn a few weeks ago when the Supreme Court issued an order making it clear and asking for supplemental briefing. I say asking, but that's a nice language, but it means ordering when it's the Supreme Court. Tell us about the phrase regular forces in Section 3 of 10 U.S.C. 12406. The United States is saying there's no review. Doesn't seem the focus of the Supreme Court. They're saying there's a rebellion, and Illinois is saying otherwise, but that doesn't seem to be the focus of the Supreme Court. And they're saying under Section 3, the United States is unable to do the job of kind of keeping order with regular forces. And they went ahead and analyzed that, as did Illinois, saying, oh, you can still do it, said Illinois, with all you have there, including state authorities. The administration said, we're having rocks thrown at us sometimes. And Illinois said, yes, that's what law enforcement's for, to arrest, etc. And then the whole thing got turned topsy-turvy by a single amicus brief by a Georgetown law professor named Marty Leerman, who we talked to at length last week in a Substack, in a YouTube, and also have a Substack about his really consequential and lone amicus brief, which says regular forces encompasses the military of the country, Army, Navy, Air Force, Marines. And what that section therefore means is they can't get the job done even with all of the regular military forces. And this totally flummoxed the administration. And it came in, and we talked about it at the time, including with Marty, and just said, basically, that doesn't make sense. And a sort of policy argument, in general, we don't want the military executing domestic law enforcement, and we surely don't. That's what posse comitatus is all about. And this would generally interfere with the normal state of affairs, and would also, it's directly contradicted by a case, a 19th century case called Martin versus Mott. I'll get back to that in a moment. Illinois knew a gift horse when it saw it and came right in and recapitulated the Leerman line, as did Leerman last week, saying, whatever the U.S. wants to say, here's the text, here's the structure, here's the tradition. And Leerman had gone back and had done his homework. And it really looks like if you analyze this statutory term, the way the court analyzes statutory terms, it encompasses the military, which of course would blow the whole administration operation out of the water. They wouldn't, they'd have to go back to square one, and also would, completely bring an end, I think, to this case, which, recall, it's up there on emergency order, and they want the Supreme Court to tell the courts below, both the district court and the Court of Appeals, which agreed with it, stop trying to prevent us from bringing in the National Guard. Okay. And now we have the submissions from yesterday, reply briefs, not from amici, just the U.S. and Illinois. The Illinois brief is what you would expect. They say, wishful thinking, good try, administration, but it's just a policy argument, and the text and structure and everything else that the Supreme Court looks to all point in the direction of it including regular forces. And obviously that's the very argument that really tied the court in knots, or really was focus and vexing, and they're going with the tailwinds there. And the United States comes in, doesn't even try so much. It knows that game is lost, to say you must completely defer. They do try to say you need to entertain a presumption of regularity. It's got two problems, of course. One is that would have been fine in a previous Department of Justice, but if anything now, there's a presumption of irregularity from the squirreliness and sort of say anything stance of the Department of Justice to execute on Donald Trump's orders. And then second, it doesn't get you there, which is the most important point. And the one I'm most anxious that the Supreme Court not contradict. It can say, okay, we give some kind of actual deference, but that doesn't get you to propositions untethered from the facts, in the memorable phrase of the Portland District Court judge. And likewise here, it sure looks like from the order they want to do statutory interpretation. That is, the judiciary does it. They interpret the terms. And that would be a giant step in the direction away from what I and others fear, greenlighting some crazy ass interpretation by Trump that would then permit him to go to town with emergency powers in all kinds of settings, including, most importantly, the upcoming elections. All right. I want to do a little more law because it really is figuring in the parties' submissions now, and that's the case of Martin versus Mott. There's a statement in there to the effect of the president decides, and the U.S. just goes to town on it. But just looking at it, even superficially at the facts, it just doesn't fly. What happened there is there was a subordinate executive officer who wanted to second guess the interpretation by the president of what's the meaning of regular forces. It didn't have to do with military or anything, just what's the meaning. Basically, he didn't want to follow the order, and the court said clearly, the president, you don't get to contradict the president, pal. That's the president's call, but it's got basically nothing to do with either the question, does regular forces encompass the military, nor, most importantly, does the president have deferential or final authority vis-a-vis the judicial branch, which is everything that is at stake here. And not to mention, this is a very sort of old, hoary case that 20th century jurisprudence, especially the famous Justice Jackson opinion that I think you may hear about also in the Steele seizure case, has well superseded, and basically is the real guidepost for when the president can have conclusive determinations. Just want to sort of put in that marker for Martin versus Mott and tell you the administration is all wet on it. And if they are, what that leaves is a sort of policy argument that, wow, we don't normally think of the military as being part of regular forces, and we don't. But then there's the text and what dictionaries say, and the structure and everything else that Leerman brought to the surface. And now the case is submitted. And remember, it's an emergency petition, so the Supreme Court, which has probably been thinking about it in the interim, could decide anytime. And the order and the briefs that came in since give much more reason to hope that the court won't do something damaging and foolish by letting Trump run to town with his determination. And in fact, I think the odds are that this kind of intervention out of nowhere from Leerman will wind up changing the whole case. And you'll see an opinion that goes off on the meaning of armed forces and hopefully the meaning that Illinois and Leerman attached to it to include the military. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.